Okay, so this is chapter 9, and we'll be dealing with online speech and defamation. So since chapter 7, we've been dealing with wrongdoings. So in chapter 7, we looked at crimes, most crimes in the cyberspace, the cyber crimes, and those are known to be social wrongdoings in which the state will mainly prosecute the accused. And then on chapter 8, we looked at torts and some online torts. So those were the civil or private wrongdoings, whereas the victims, they have remedies. Most likely, the main remedy is monetary compensation, but there's also injunction available for those wrongdoings. And today we'll be dealing more specifically with defamation, freedom of speech. So they are contrary to one another, meaning that we do have the right of freedom. We do enjoy the freedom of speech. However, as I'll show to you, it is limited at certain extent, and if it goes beyond what is permitted, then the person issuing a statement, speaking out loud, may be committing the tort of defamation. And remember that we also checked on chapter 8, small or light difference between false light and defamation. So we'll be focusing more deeply here in defamation. But just to remind you, or to make you remember, that false light was when a third person made public an attributed view of ours, and that attributed view was wrong. So I've given you the example, someone making public that I am for Biden, but actually I am for Trump, or vice versa. So that is a false light, the tort of false light. So there, I would not be, remember I mentioned that. It's more about what others think about me, whereas in defamation, there's harm, damage to my reputation, who I am, what I do, etc. So we'll be talking about the scope of the First Amendment, where the freedom of speech, freedom of press are. And then we'll look at the definition of defamation. We'll also see why those two terms exist, libel and slander. And then we'll be discussing the elements in a defamation action. So what is required for the plaintiff to establish in a defamation lawsuit. And then we'll look at some defenses. So defendants may claim defenses that are related to the CDA, the Communications Decency Act, or some other defenses we'll see. And then very briefly looking at criminal prosecution, which actually does not happen much. And we'll end by looking at the elements of business disparagement or injurious falsehood. In other words, this is actually business defamation. So when the reputation of a business, of a service, of a product was harmed. So let's start with the scope of the First Amendment, looking at the freedom of speech and press. So the First Amendment says, Congress shall make no law abridging the freedom of speech or of the press. So there can't be any laws that would interfere with our freedom of speech or with the freedom of press. And that is very, very important law in the US. That is a very, very important right American citizens enjoy. And by the way, the Communications Decency Act had some of their sections, some portions actually, regarded to have violated the First Amendment. And such violation was based on what is called the overbreadth doctrine, because, in other words, those portions, they were so broad that they were violating, they were interfering with either the freedom of speech or the press. So what specifically happened was that those portions of the CDA, they aimed at preventing minors from receiving some sexual content via the web. However, such attempt to prevent also interfered with the ability of adults. So this could also make adults not to be able to receive some sexual content. So the way it was drafted, the Supreme Court regarded this as violating the First Amendment, even though the objective could have been good. However, they understood it violated the First Amendment in with regards to the freedom of speech. So this is a clear example on how important this freedom, this right is in the US. Again, most people would agree that preventing minors from receiving sexual content via the internet is good, is very, very good. However, the freedom of speech, freedom of press, those are so important freedoms that Americans have that while balancing those freedoms, those principles, and the goal of those portions of the CDA, the Supreme Court decided to strike down those portions. So that's a clear example here. So I emphasized how important the freedom of speech is. However, it is not an absolute right or freedom. In other words, such a freedom has limits, has boundaries. And where are those boundaries? Well, everyone enjoys the freedom of speech, except for obscenity, for fight words, for defamation, so a false statement we'll see in a while, for perjury, for blackmail, for true threats, or for solicitation of crimes. So if we have speech, if we enjoy our freedom of speech, but use any of those, then the First Amendment will not be of protection. So again, freedom of speech, not an absolute right. There are boundaries, there are limits, and those are the main limits. Okay? If we come into a speech, a statement in which any of these is present, then we have gone beyond our freedom of speech. Hence, we may have to face the consequences. Okay? There's also the concept of expressive conduct. So, expressive conduct, when we act in certain way, or when we get the message through a conduct, not through words only, but through personal conduct, or such as the examples I have here for websites or for computer code. So they may also be protected by the freedom of speech, by the First Amendment. So two interesting cases here, Jungler versus Daly. So this first one, the courts understood that a computer code is indeed an expressive means for the exchange of information and ideas. Hence, computer code is protected by the First Amendment. Hence, the limitations for computer code, they have to be narrow because they are protected by this freedom of speech, by this freedom of press. Okay, so there can't be limitations to computer code. On the other hand, in Butler versus Adoption Media, the court held that the defendants, Adoption Media, they were in business of selling adoption-related services. So being in service does not entail an expressive speech that is protected by the First Amendment. So if there's no protection under the First Amendment, then the boundaries here will be more limited. In this case, a couple of the same sex wanted to advertise, they wanted to adopt, but they were prevented from doing so. And here, such prevention or prohibition from Adoption Media, the defendants, they claimed they could do this because they had protection under the First Amendment, but the court said no, you do not enjoy such protection because your website and your business is not an expressive conduct. Hence, it is not. It does not enjoy protection under the First Amendment. Moving on, so we'll define defamation and then libel and slander. So defamation is an act that harms the reputation of someone else when a false statement is made to a third person. Well, here's some important aspects. First of all, there has to be harm to the reputation. And the statement has to be false, will be false, and the statement is issued to a third person. So if you say a false statement, if you issue a false statement directly to the person the statement is about, you are not issuing it to a third person. So if someone calls me an illegal worker in Canada, it is false because I'm not an illegal worker. But if someone talks to me and says, hey, you are an illegal worker in Canada, this is not defamation because, it could harm my reputation. However, it is being said to me. It's not being said to a third person. But if there are others around, if they listen to this, then this third person requirement would be met. Okay? So libel and slander. Libel is written defamation, and defamation that is posted online is also known as libel. Libel should also be understood as defamation that leaves some records. So if there's a written evidence, written piece, if there's, let's say, recording, this could be considered libel. Whereas slander, and you will see that I have underlined the S for slander because it is a spoken verbal defamation. So SS for an easier remembering. So slander is spoken or verbal defamation. Slander should also be regarded as defamation that leaves no record behind. So in this case, you would need, for slander, you would need a witness. So someone who witnessed the speaking of the false statement that would have harmed someone else's reputation, because in principle, slander, by being spoken, by being verbal, defamation leaves no record behind. Okay. Um, Actually, nowadays this difference is not so important. Everything is defamation. They did come up with this difference between libel and slander, but everything is defamation. So if you just know as defamation, it is good. Okay. Again, libel will leave a record behind. That's why it's written defamation. Also, if online, posted, email, website, etc. Libel, cyber libel, and slander, spoken. So slander will be spoken or verbal defamation. Let's look at the elements. I explained a bit, but let's go deeper here. So for a victim of for an alleged victim of defamation, they will have to prove in court that the defendant made a defamatory, a bad communication to a third person. So the statement is defamatory. The statement hurts or may hurt the reputation of the plaintiff, of the victim. And that statement was false. Again, my example, someone posts online that the B-law instructor is an illegal worker in Canada. So posting online, libel, cyber libel, it is false, it is to a third person. So the elements for a defamation action will be there. The defendant, the wrongdoer, tortfeasor, would be at fault, would be acting wrongfully while communicating the statement, and the victim would have suffered harm. Harm would be there, harm to their reputation. So those are the requirements for a defamation action. Whenever you think someone else acted wrongfully towards you, committed a defamation against you, those are the requirements you have to look at. Does it does it involve my reputation? Can it cause harm to my reputation? Was it spoken or written to a third person, not only myself? And is the statement false? So those are the requirements you have to look at. Now we look at the defenses. So let's say you are suing someone for defamation. So this defendant, they may have some defenses available to them. Well, the first one we look at is the one prescribed by the CDA, the Communications Decency Act, on Section 230. And this defense is available to certain websites, the websites in which there's interaction between users and the website, such as postings, area where you can log in and do things on the website, or for ISPs, internet service providers. So it is said that there's immunity for those certain websites and also for internet service providers, as long as third parties, users, they communicated a false statement. The website itself, the internet service provider itself, they are not liable. They are immune. However, if the website itself, let's say the owner of the website, if they communicate a false statement, then they may not enjoy the protection under Section 230 of the CDA. Okay, so this is when a third party, third person, could be anonymous or not, but it's not the company itself that communicates. Another defense is known as privilege. So there are people that have some privileges. There are people that can issue false statements, and because of their position, because of what they are doing, they need to have such protection so that they can speak out whatever is important, whatever is of public interest. So, for example, for absolute privilege is absolute immunity. Someone who has an absolute privilege is absolute immune from being sued for defamation. And those are members of Congress, members of the judicial, legislative, or administrative proceedings. So, for example, a politician, the best way to memorize here. So a politician, when they are in parliament or at the legislature, they have to be free to speak out about their opponents, about the other parties, about people, etc. But while they are in parliament, while they are actually acting as a politician, if they are not acting as a politician, if let's say on the weekend they are acting as just normal citizens, people, they would not have this absolute immunity. But while performing their jobs, judges or witnesses, while they are in any judicial proceedings, they are immune of what they say. Okay? Whereas qualified privilege is a different type of privilege, it also brings some immunity, but not absolute immunity. So qualified privilege is present when there's a legal or moral duty. So the example here, employers and employee. Let's say the employer, the director, the boss, the manager, supervisor issues a statement, a false statement about an employee, but only to people who would need to know. So let's say the supervisor is issuing a false statement to a small group of people, just the people that belong to their department, and makes a mistake, not based on malice, but based on mistake, communicates this false statement because the supervisor did it in an employment relationship and without malice. Even if the employee sues the supervisor for defamation, the supervisor would be able to claim the qualified privilege defense, because the supervisor would say, well, I was performing a legal duty, it was work at a workplace, it was out of malice, there was no malice, it was just communicated to a very small group, the ones who were at the meeting, etc., etc. Another example here is when police officers are investigating something, or another example, when the family doctor issues a note to the specialist, and then let's say there's a false statement in that note, but the false statement is going only to one person, the specialist, and also it's going because it has to. So you see, there's no malice, there's mistake in here. Then qualified privilege could help here as a defense. Okay, so the two types of privileges, the absolute privilege, you can remember for politicians, and the qualified privilege. So this one requires a special relationship, such as employer-employee, doctor, family doctor and specialist, and so on. Another type of defense, and this is an absolute defense, is truth. So let's just come back here. For the requirements, one of the requirements for the defamation action is that the statement was false. Well, if in the defense the defendant proves that the statement is actually true, there was no false statement, then the action has to be dismissed. So truth is an absolute defense. If proved, then the action has to be dismissed. Another defense is an opinion. Well, I'm going to use myself again. So one student or a group of students, the whole class, they could say they don't like my course, they don't like the way I explain, they could post this online, they could make a review. So if it is opinion, if we're talking about opinion, it is no defamation because it's not a false statement. If you say you don't like the instructor, if you say the activities that were or are presented, they are not effective, if you don't like the pronunciation, or whatever opinion you have about a person, this is not necessarily a defamation and a false statement. But again, it has to be an opinion. You cannot make an opinion about a false statement. So, I believe the instructor is an illegal worker in Canada. Well, I'm not sure, but I believe it's just my opinion. No, you cannot say this because the statement itself is false. But you can say, hey, I don't think this instructor should be delivering this course because of this quality, this issue, etc., etc. Then these would constitute your opinion. Hence, you could claim this as a defense in case the instructor ever sued you for defamation. And another defense is consent. Well, if the plaintiff, the victim, has given the defendant consent to communicate that statement, that false statement, then there's no defamation because there was consent. And consent here is usually implied by conduct, but defendants would be better off if they could prove in writing or with a witness or with recording they had consent to issue that false statement. Another defense, the second one, when the plaintiff is a public figure. So for celebrities, when the plaintiff is a public figure, the communication of the false statement requires actual malice. So actual intention, actual bad intention to communicate that false statement. So let's say Justin Bieber, a celebrity, if someone says by mistake, without malice, that Justin Bieber has alcohol issues, for example, or any other issues, but without malice, without the intention to create harm, because Justin Bieber is a public figure, if Justin Bieber decided to sue this person, the defendant would be able to claim as a defense that Justin Bieber is a public figure. There was no actual malice, hence the lawsuit has to be dismissed. And this last one, the anti-SLAPP laws. So SLAPP stands for the Strategic Lawsuit Against Public Participation. So there are laws, and those laws are called the anti-SLAPP or cyber SLAPP. This came into existence because there are some strong groups or even strong financially people They don't want to be exposed in issues that are of public interest. So they decide to sue for defamation just because they are powerful. They have money to pay legal fees, etc. But their lawsuit is meritless. It has no merit. They are just suing because they want to avoid that matter to be discussed in public. So they want to use the defamation lawsuit um, as a way to prevent people from discussing that public matter. So those are laws that, in case the judge finds a defendant, someone being sued for defamation, if they believe that defamation lawsuit is being used just to prevent them from speaking out, they can bring this as a defense. And if the judge understands and considers that there was no false statement, the statement may be a statement of public interest, maybe a debatable statement, and that lawsuit is only aimed at stopping the discussion, then the defense will be successful and the lawsuit will be dismissed. Okay, so those were the defenses for defamation. Now, the last part is about business disparagement, and synonyms for distort is also business defamation, injurious falsehood, trade libel. So those three, they are used a lot as well. Business defamation, injurious falsehood, and trade libel. And what is this? Well, this is when damages may take place with either a business or service or product. So in this case, the defendant, the wrongdoer, made a disparaging remark that intended to injure the business or the product or the service, and the defendant either knew the statement was false or was reckless in order to learn whether it was true or not. So let's say I go online and I say, Starbucks coffee comes from slavery farms. Well, if this is false, and I believe this is, this would be an example of injurious falsehood. Because I told you, I believe it is false, but in the best case scenario, I'm being reckless, not checking if this is accurate or not. Okay? So if this causes damages to Starbucks because they stop selling coffee or their sales go down, even if it's locally in a small region, then I would have committed the business disparagement or business defamation tort. Okay? So again, opinion is fine. I may post online or I may tell people that I don't like Starbucks coffee. Their blonde coffee is not good. Or even Tim Hortons, I don't like the black, the double black, or McDonald's coffee, or whatever it is. We can communicate our opinion. But if we are communicating a fact and that fact is false, and that false fact causes damages either to a product, business, or service, then we would be committing the business defamation tort. Okay? So that's what I wanted to share with you about online speech and defamation. We looked at the First Amendment, the protection there on freedom of speech and freedom of press. We also looked at the definition of defamation, and We saw what libel is, slander is. So libel, written defamation, leaves a record behind. Slander, spoken defamation or verbal defamation, does not leave a record behind. And then we discussed what is required for a defamation action to be successful. So the statement has to be defamatory, has to be communicated to a third person, has to be false, and has to cause harm to the reputation. And we looked at some defenses, the ones available at the DCA, the Decency Communications, Communications Decency Act, CDA, Section 230. Available, those immunities available for internet service providers and certain websites. We also looked at truth, consent, opinion. Also, we looked at actual malice that is required for public figures, the anti-SLAPP laws to bar meritless lawsuits, and also the privileges, the absolute privilege for politicians, members of the judicial, legislative, or administrative bodies, or the qualified privilege that requires a special relationship, such as the examples of employer, employee, family doctor, specialist. And we ended looking at business disparagement or injurious falsehood. Thank you, and I see you in our last chapter, chapter 11. Bye now.